Good evening and welcome to another edition of Chicago Counterpoint. Chicago Counterpoint is brought to you by the Fatherhood Educational Institute, a Illinois non-for-profit corporation and partners with the U.S. Department of Education. Chicago Counterpoint is usually brought to you by Jeffery Leving, attorney and author. He is unable to be with us tonight as he is on another TV show, but my name is Tim O'Grady and I'm stepping in tonight for Jeff Leving, and with me tonight is attorney Art Kallow. Welcome to the show.
Very good to be here. Thank you, Tim.
Good to have you. Art Kallow, who I've known for years, is a very talented attorney, licensed to practice law in Illinois, and he has practiced in the area of family law for many years, and actually has the unique experience of representing children in child custody situations. Is that correct?
That's right, Tim. I'm on the panel of attorneys to represent children. In Illinois, there's a whole system to have attorneys appointed to represent children, usually as child representatives, and I'm on that panel. Very
good. If anybody has questions, they can call in about the Fatherhood Educational Institute. You can call 312-7950. That's 312-795-9060, actually. 312-795-9060. And we have a number of callers that had called in last week, but we didn't have you on the air. We didn't have time to, so by all means call back with questions that you had from last week. And we also are having a book giveaway this evening. If you call 312-795-9060 and leave your name and address and a phone number if necessary, and we can send you a free copy of Jeff Leving's book, Father's Rights, Hard-Hitting and Fair Advice for Every Father Involved in a Custody Dispute. And there we go. Now, what has been your experience with dealing with adults as opposed to children in child custody cases?
Well, when I deal with adults, they can come in and tell me exactly what they think and what they want. And if they hire me to be their attorney, I really have a duty to try to get them what they want. Children, on the other hand, sometimes aren't able to articulate what their feelings are, and oftentimes, as an attorney for the child, if I'm a child's representative especially, I have to really advocate what's in their best interest, regardless of that's just what they're saying. So I really have to use different skills in representing different sorts of clients in that regard.
Very good. And I would like to let our viewers know that Jeff Leving is also the chair of the Illinois State Council on Responsible Fatherhood. Now, this is not a not-for-profit organization, but this is a department of the state government of Illinois under the Department of, I believe, Healthcare or Family Services. If you call 312-795-9060, we can send you a brochure. There's an Illinois Father's Resource Guide that has a lot of good information, including addresses and phone numbers for resources for fathers. Now, what kinds of considerations does the judge make in a custody case? What are the factors that the judge looks at?
Well, the statute in Illinois in the Marriage and Dissolution of Marriage Act sets forth various factors. One would be the best interest of the children is the most important, and the factors that are considered in determining that would be the wishes of the parties, the mother and father, the wishes of the children, and many other factors that relate to the best interests. Oftentimes, the best interests can be determined by talking to the parties, by listening to what the parties do for the children, what they want to do with the children, and the amount of time that they spend, and so forth. In some cases, obviously, we can't agree in that way, and we have to look at much more complicated factors, such as psychological factors, and that would often require a psychological evaluation, but either by a psychiatrist or a psychologist or a social worker.
Now, how does a child representative get appointed on a case?
Generally, after the parties have had an opportunity to see if they could settle the case themselves, the court will appoint an attorney if they haven't been able to do that, either to act as a child representative or to act as an attorney or to act as a guardian. There's slightly different functions of each of those particular appointments, and the court actually determines who should do that. So oftentimes the parties choose somebody and approach the court. It has to be someone who's on the panel of attorneys because there's a state law that sets forth the qualifications to be a child representative. And then the court appoints the attorney to do that, and if the attorney accepts, then the attorney knows he has a client, and the children know that they have an attorney to help them in the case.
Very good. And now you've also got a number of years of experience representing parents in domestic litigation, correct?
Certainly, yes. I have many years representing parents in custody cases especially, and they can be very grueling and very difficult cases, but it's very rewarding when we're able to get custody for a father especially, and oftentimes for the mother, but usually we represent fathers.
Very good. Now, how is child support determined under Illinois law?
Well, generally child support is determined by a guideline system that says the percentages that have to be paid depending upon how many children one has. The non-custodial parent usually has to pay child support based upon his or her net income as defined in the statute. And for one child it's 20%, for two children it's 28%, and it goes up after that.
You know, one of the things that I've dealt with in my representation of parents in custody proceedings, litigants will say that they want their child to talk to the judge. Mm-hmm. What is the procedure for getting that done?
Well, in order for a child to talk to a judge, the child generally is interviewed in camera, which is Latin for in the room, in the judge's chambers, the judge's office. And most of the judges in the county and other counties have specialized training in how to interview a child, and they do it very carefully, with a lot of sensitivity and so forth. Generally, children do not walk into the courtroom and subject themselves to vigorous cross-examination like you would see on television. Mm-hmm. It's a less formal procedure that requires the judge to take control and ask the question.
Now, it's been my experience that judges don't appreciate it if a parent brings a child to court without the judge asking the parent to do that.
That's true. In fact, I've seen very many times when the judge will instruct one of the deputies, the bailiffs in the courtroom, to escort the person who has the children out of the courtroom and have the children wait someplace else. In Cook County, there are nurseries, and they have them in other counties as well, that will look after children during a court appearance.
Very good. I know in particular the courthouse at 32 West Randolph and the courthouse at the Daly mm-hmm. Center both have child care centers there. And another frequent question I ask is that I get asked from litigants is, at what age can a child say where they want to live?
Usually when they get to be 13, the court starts listening to them, and every year after that they have a little bit more authority to give their opinion on where to stay. When they get to be 16 or 17, it's obvious that they can make up their mind. When they're 15, the judge will listen very carefully to them as well.